You brought in your 136-page complaint against Binance and C.G. Zhao. A lot of these things are things we've seen in other forms without crypto. Is this a crypto case as such, or is this a pretty straightforward securities case?
You raise a good question. This is actually a straightforward securities case, but it's in the context of crypto. And let me just say, crypto tokens, the investing public needs that same disclosure, a full, fair, and truthful disclosure, we say. And in the crypto space, it's largely built on a business model that's non-compliant with the securities laws. People are commingling all of the customer funds. It would be as if the New York Stock Exchange is also operating a hedge fund and trading against their customers, or add to it, that they don't have proper controls to avoid manipulative trading on the platform by their sister. So here, Binance had a sister organization controlled by Mr. Zhao called Sigma Chain. So absolutely, it's straightforward. Protect the public through the securities law, build confidence and trust, but it's in the context of crypto.
You have said elsewhere that there are certain custody rules here that registered financial advisors have to pay attention to when it's something like Binance. Are you looking at some of those financial advisors for possible violations?
Look, I'm not going to get into any one investigation or case that we haven't yet brought, but I would say this to all of those investment advisors out there that may be interested in trading in crypto. Your client funds, under an existing 2009 rule, have to be proper qualified custodians, and that's not what you have on Binance. Make no mistake. In fact, as we alleged, your funds in custody at Binance, you don't even know really who's where it is. You know that Mr. Zhao ultimately is controlling it, but it may have actually moved it to a sister organization. There's another one that we allege, Merit Peak, that billions of dollars of funds were moving to.
Good early afternoon, 12:49 p.m. Eastern Standard Time on this Monday, June 12th, 2023. I'm XRP Future Millionaire, and I reside in the great state of Michigan. So as you've seen in that just about 2-minute clip that I played, Gary Gensler is not backing down. He's also warning and reiterating of further lawsuits to be filed. He's warning brokers to pay attention to the 2009 law put into place by Obama, is essentially what he's saying. So that's a very big deal. Now, I hope you paid attention to that video because he said a lot of things in there, and we'll unpack it today during the live, and I'll play a little bit more of it during the live as well, but that'll give you a little sneak peek. If you want to join me in the live at 2:30 p.m. Eastern Standard Time here on YouTube, that is completely up to you. We've had a great vibe in there. We have a very nice inclusive environment. Now, I'm liking this inclusiveness. I'm liking this positive energy. I'm also liking the spirituality in the comments. So I think we're doing something here now. We're starting to have the inclusive feel and not the exclusivity, and that's the most important thing. I want to go over a little update now in regards to Ripple versus SEC case update as of June 12, 2023. If you want to see technical analysis, watch my update from about 2 hours ago. And then if you want to get some further information, you might want to learn how to do some technical analysis, or you just want to ask me some questions, join me at the live at 2:30 p.m. Eastern Standard Time. So Ripple versus SEC case update as of June 12, 2023. As we know, tomorrow is a very important day because the SEC's on the clock. The courts told them they've got to answer by tomorrow, so we're waiting to see exactly what they do. So with the release of the controversial documents just 1 day away, the cryptocurrency industry continues to follow the people close to the legal battle that the United States Securities and Exchange Commission SEC is wagering against blockchain company Ripple for any insights in the case. In this context, legal expert and amicus curiae for Ripple, Johnny Deaton, commented on the possible effect of the emails publicly released on this case, as well as other lawsuits that the regulator has initiated against cryptocurrency businesses in the meantime, according to the tweet he posted on June 11th. And if you're wondering, it got cold in Michigan, and it doesn't seem cold because it's in the 50s, like low 50s, But when it was in the 90s and 95, all of a sudden getting into the 50s, now it's a little chilly. It's a little chilly. 2 months ago, this would have been warm. We would have been in shorts, but man, now it's a little chilly. So, all right, so what HINMAM release means. As he explained, the document referring to a speech that former SEC Division Director William HINMAM delivered at a summit in 2018 where he said that Ethereum and Bitcoin were not securities could have an even more significant effect on the public and relevant policymakers. The emails won't change the Howey analysis, but they will likely show the difficulty in applying 1930s-40s precedent to modern-day technology. The emails will likely help Coinbase and Ripple in the court of public opinion and hopefully drive bipartisan efforts in Congress. That's what we're trying to see. That's what I was alluding to. If Congress wants to continue holding their seats, they're going to have to pass some kind of legislation or at least draft something that makes it, at least on illusion, make it look like they're supporting the public. At the same time, Deaton predicted that the emails will highlight HINMAM's massive conflicts of interest and that people will ask, then why the speech? Based on the conclusions he drew with the help of the crypto community in late 2022. As a reminder, in December 2022, he wrote, who cares? All issues with SEC's positions. On June 11th, he shared the SEC's response to his writ of mandamus he had filed in January 2021, in which the regulatory agency admits that the court decides if a SEC's claim or theory is even valid, to which Deaton added that the SEC calling an asset a security does not mean it is a security. Thus, the Commission's enforcement proceeding in the Southern District of New York, brought under the Securities Act, supplies the exclusive method for testing the validity of the Commission's complaint against Ripple. So on June 12th, that's just a little update bringing us to today's date, or to tomorrow, when supposedly the HINMAM emails or docs are supposed to be released, but will the SEC actually comply? They're also ordered to respond to a few different things by the U.S. courts. They had an extension leading to tomorrow as well. So we're going to see how this exactly plays out. This is going to be a very, very interesting day tomorrow. So I just wanted to give you a little update. It's not much, but it was a little backstory of what was happening leading up to tomorrow. So now I want to end this. I'm going to play just about another minute and a half of what Gary Gensler says. If you got anything on this update, if you want to support my work, make sure you hit that subscribe button. And consider joining Tom's Army, but the most important thing is join me at 2:30 p.m. Eastern Standard Time so that we can talk more personably, so you can get a better look at the community, and so that you can be a part of something bigger. Make sure you hit that like button, as it will greatly help push me through the analytics.
We're moving to.
So that raises another question about the extent to which what you're seeing with respect to Binance and Mr. Zhao may well apply to other companies doing similar things. Do you have similar custody problems with other people dealing with crypto? Obviously, this is the largest exchange there is, but other similar entities.
I would say this, it may be the largest exchange because we allege that they had corrupted their trading volumes by a lack of risk controls about their affiliates, Signet Chain and Wash Trading. But moving on to your question, there are challenges of custody throughout this space. And secondly, there's a business model that bundles and commingles functions that we don't see, nor would we allow elsewhere in finance. And so there's parallels here to the FTX fraud and manipulation that we saw and we allege against Sam Bankman-Fried, where he had a sister organization, Alameda, and the special arrangements with that trading platform, FTX. You see platform after platform that the entrepreneurs behind the platform also are trying to build wealth for themselves and their investors through sister organizations, hedge funds, trading against the customers, or even as it relates to where there might not be a sister organization, that they're dealing against their customers.